Good afternoon, everybody. Thanks for joining us for, I've lost count. It should technically be the seventh webinar in Conn Carey's annual OSHA webinar series, but we've had a bunch of bonus webinars this year because there have been so many sort of crazy things going on in the world of workplace safety and health. The obvious one being the coronavirus and implications of the pandemic in the workplace, but also a bunch of other interesting developments even before that, the CSB rulemaking on reporting and some other issues. We had already scheduled to discuss in July OSHA's General Duty Clause, which is fortuitous because that is the primary lens that OSHA will be looking at COVID-19 issues in the workplace. So as we cover the General Duty Clause today, we're going to cover it in a general way and some specific examples. And then we've also included a section on COVID-19 because that is the big issue of the day, of course. Just real quickly to introduce ourselves, the first faceless voice that you're hearing right now is Eric Conn. I'm one of the founding partners at Conn Carey, and I chair the firm's national OSHA practice group. I've practiced now, I looked up this year, sort of startled to see this is my 20th year in practice, and almost entirely that 20 years has been focused on pretty much exclusively workplace safety and health law. The first 11 years I practiced alongside the former first general counsel of the OSH Review Commission, and since then started my own practice at a big national employment law firm. And then 6 years ago, we launched Conn Carey, which is a boutique firm, a national boutique firm focused on workplace safety and health law issues and labor and employment law. I represent employers in all aspects of OSHA law, from responding to catastrophic incidents, helping to manage inspections, and of course enforcement actions involving OSHA and all of the state OSH plans around the country, as well as a host of other kind of soup to nuts OSHA issues. These days, I thought I was an extremely specialized attorney focused just on OSHA law, but really this year, we've become even more focused almost entirely on COVID-19 issues in the workplace, helping employers develop exposure control plans, responding to the now thousands of employee complaints. I don't think we've responded to all of them, but it feels like it. Tens of thousands of employee complaints to OSHA and the state plans about employers' responses to the pandemic. And now recently, the wave of OSHA enforcement inspections that have begun involving COVID-19. We've been in the thick of all of that and are going to talk a little bit about that at the end of the program today. I'll let my colleagues introduce themselves and then we'll jump into the topic.
Hi, my name is Amanda Strainis-Walker, and I'm also a partner in the OSHA practice group. I'm based out of Atlanta and work on all aspects of occupational safety and health law, whether it's enforcement, compliance, or petitioning the agency for letters of interpretation. It really runs the gamut. I got my start in OSHA law, starting with the agency back in 2005, and have continued to focus on this particular area of the law. Thank you.
And hi all, my name is Beeta Lashkari. I'm an associate at Conn Carey and a former attorney investigator of the U.S. Chemical Safety Board. I represent employers in the full range of matters regarding the OSH Act and handle the full range of litigation related to contesting OSHA citations. I also manage inspections and investigations by OSHA, the CSB, EPA, and other federal, state, and local government agencies. It's a pleasure to be here with you, and I'll turn it back over now to Eric to go through our agenda for today's webinar.
Thanks. So yeah, today is all about the General Duty Clause. We're going to start off with a discussion about the context. Where does it come from? What are the key provisions of the OSH Act that give power behind the General Duty Clause? And what are the elements that OSHA has to establish to prove a violation of the General Duty Clause? And then we'll talk about some enforcement trends, subject matters, areas where we're seeing OSHA use the General Duty Clause most often, and then some recent important decisions from the Review Commission and some federal circuit courts about General Duty Clause cases. And then we'll get into some common defenses, limitations to the General Duty Clause, And then finally, we'll, as I think is obligatory these days, we will be talking about COVID-19 and how that interacts with OSHA's general duty clause. So let's get started with some context about the general duty clause. I start off with a provision of the Act that is not the general duty clause, and that is section 5A2. Those of you that are in this EHS world, you know that 5A1 is the provision we're going to be talking about mostly today, but 5A2 is the one where you deal with OSHA most often. That is the provision of the OSH Act that requires employers to comply with specific regulatory standards promulgated by OSHA pursuant to the Act. So that is the authority of OSHA to enforce and the duty of employers to comply with specific standards like lockout, tagout, fall protection requirements, personal protective requirements, where OSHA has promulgated a specific standard. Now, the one that is most relevant for today is everything else, right? It's where there is not a specific standard. We look to section 5A1 on the next slide. That is the general duty clause. It's affectionately referred to as the general duty clause, but really it is section 5A1 of the Occupational Safety and Health Act of 1970. And that provision requires, since we're going to be talking all about it today, I'm going to read the actual provision to you. It says that each employer shall furnish each of his employees employment and a place of employment which are free from recognized hazards that are causing or likely to cause death or serious physical harm to his employees. When I describe it, I usually say that it's the provision that requires you to provide a place of employment that's free of recognized serious hazards. And that's what the general duty clause is all about. So what falls within that 5A1 or what doesn't? The questions that we debate the most often among our team on the next slide, and that you see often raised in litigation about the general duty clause, or that you see raised in rulemakings or in petitions to require OSHA to promulgate a rule, is what is this general duty clause for and what is it not for? Is it a catch-all provision? Is it to catch everywhere that there's not a specific standard? We want to make sure that OSHA has enforcement authority over every hazard that's out there. Is it intended to just fill the gaps where OSHA has not promulgated a specific standard? Or some people debate and assert that really the purpose of the general duty clause when it was promulgated was as a placeholder for those hazards that were becoming recognized, right? One of the elements is that it's a recognized hazard, that it's recognized as a key and important hazard that should be regulated. So you use 5A1 as an interim enforcement tool until a rulemaking can be completed to promulgate a rule. That's certainly not the approach that OSHA has taken in recent years. We've seen them rely heavily on the general duty clause in areas where there is no rulemaking, not even one sitting on the back burner on their regulatory agenda. But there is some basis to believe back from the legislative history of the OSH Act that that's really what the intended purpose of 5A1 was as for a short period of time while OSHA promulgated a rule, this would be a backstop for the rulemaking process. But it really has become, I think, more of a gap filler where OSHA uses it whenever they would like when there's not a specific standard. And then the last bullet here is one that is highly controversial, but an area where we are seeing a little bit more general duty clause activity, and that's activity where there is enforcement from OSHA even when there is a specific standard, and even when there is compliance with the specific standard, when there is some recognition perhaps that compliance with the existing standard does not necessarily result in safety. And the most common example of that, and we'll talk about this in some detail, is enforcing exposure to chemicals at levels lower than existing permissible exposure levels, where there is developing science that shows that it is not necessarily safe at the exposure level that OSHA has set and has been enforcing for years. Perhaps the general duty clause can fill the gap between the existing PEL and the level that science now says is a safe level. So we'll talk about that in some detail. But those are all the, sort of the academic debate about, how far should we go with the general duty clause? When does it fit? What circumstances does it fit? So, and frankly, if you ask OSHA today, and this is even in a Republican administration, they would, I think, say, whether they use these words or not, that it's a gap filler. It's not a placeholder. It's not a backstop. It's a gap filler. It's for any area where they think there is an unsafe condition, that there is not a specific standard, regardless of their intent to promulgate one, and regardless of whether there even is an existing one. If they don't think it's safe enough, they're going to use the general duty clause. So that's the backdrop here for when OSHA is going to use it. How do they use it? How does OSHA prove a general duty clause violation? There are 4 elements well established in the case law, and OSHA has laid them out pretty clearly in their field operations manual as well. These are the 4 major elements that OSHA has to prove to establish a general duty clause violation. They are that the employer failed to keep the workplace free of a hazard to which the employer's employees are exposed. The second element is that the hazard was recognized by the employer or the employer's industry. Third element is that the hazard was causing or likely to cause death or serious physical harm. And the fourth element is that there exists a feasible means to materially abate or reduce the hazard that exists in the workplace, that is recognized by the employer or its industry, and that is a serious hazard. Those are the 4 elements. Let's go through each one of them and talk about what they really mean. With respect to the existence of a hazard in the workplace, for 5A1 violation to be established, a hazard is defined as a workplace condition or a workplace practice to which employees are exposed that creates the potential for harm to employees. Ignore that death or serious right now, because that's really a separate standalone element. To me, this initial element is just, is there a hazard, period? Is there a hazard in the workplace that is present because of working conditions or practices in the workplace? OSHA, to establish that, has to show, thanks. Siri is going to help me present this program today. The hazard must be defined or definable in terms of the presence of a hazardous condition or practice. If OSHA cannot define it in a clear way, then it is not properly citable. And the hazard must be a condition or practice that can be abated by the employer. It has to be something that can be addressed by some act or policy or equipment or protective equipment or something like that. If it's something that cannot be addressed by anything that an employer can do or provide, then it is not a hazard covered by Section 5A1. So that's sort of the basics of hazard. And a couple more points about that, starting on the next slide, is that, and this is true in all contexts, not just the general duty clause, but it's particularly relevant in this discussion, that the occurrence of an accident, the occurrence of an injury, does not necessarily mean that the employer has violated Section 5A1, but the occurrence of an accident or an injury can certainly be pointed to as evidence by OSHA of the existence of a hazard, right? Someone got hurt, there was an accident, even a near miss or an accident that resulted in injury. Therefore, it is, almost default demonstrable presence of a hazard, because but for the injury, or but for the hazard, there could be no injury. So that is a common way that OSHA would demonstrate the existence of a hazard, although they can demonstrate the existence of a hazard even in the absence of an injury or an incident. On the next slide, this is an important point that is often overlooked, and that is that the 5A1 is really tricky in the context of multi-employer work sites. As a general rule, I don't think it is a absolute sort of jurisdictional issue, but as a general rule, Section 5A1 applies to hazards to your own employees, right? We talk about here, you may be the one who created a hazard, contributed to the existence of a hazard, had the authority to correct a hazard, controlled the presence of the hazard at the workplace. But if your own employees are not exposed to the hazard, you are not supposed to be citable under 5A1. And if you go back to the language of the statute itself, it talks about employers providing his employees employment that's free of recognized hazards that are likely to cause harm to his employees. So where you may see OSHA try to expand 5A1 violations in the multi-employer context. It is supposed to be that the only employer who can be cited for a 5A1 violation is an employer whose own employees are exposed to the hazard. Now, that may be multiple employers on the same work site, but they have to each be an exposing employer. It can't be that by virtue of being a controlling employer, even if none of your own employees are exposed, that's not good enough under 5A1 to establish that a hazard is present. Let's move on to recognition. This is where the rubber tends to meet the road in general duty clause violations, element 2 and element 4. That is recognition of the hazard and the existence of a feasible means of abatement to materially reduce the hazard itself. Recognition means that the hazard itself was understood and recognized by the employer or by the employer's industry. And let's look just at the first couple of words of each of these bullets here, and then we'll move on to the next slide after that. The ways that OSHA tends to try to establish hazard recognition is through industry recognition, looking at things like trade association guidance, national consensus standard guidance, or OSHA's own guidance that is issued and targeted to specific industries. As a note here, recognition by some other industry should not be enough and can be a defense to recognition where OSHA is trying to establish recognition. So for example, if there is workplace violence is a recognized hazard, generally understood to be a recognized hazard in hospitals or healthcare settings or taxi drivers or late night retail. If OSHA tries to expand that and say, well, workplace violence is recognized in those industries and there's guidance out there about that hazard in those industries, therefore it's recognized in a manufacturing setting. Well, that generally should not be enough for OSHA to establish hazard recognition because it being recognized in one industry does not necessarily mean it's recognized in all industries. Employer recognition is another way that OSHA can prove recognition. That's where the specific employer is aware of this hazard, and we know that by looking at things like their own statements, their own admissions during the inspection, or looking at written procedures, looking at inspection history where issues have cropped up involving the same hazard, or looking at audits, audit findings that identify the existence of the hazard. That would be the employer is aware that the hazard is present in their workplace because we can see that they have acknowledged it in writing or in speaking in some instances. And then finally, common sense. And this is kind of that reasonable person, reasonable employer standard. If the recognition or the presence of the hazard is so obvious that any reasonable person, any reasonable employer would have recognized its presence in the workplace, then that is recognition. So that's that, just like proving other elements of OSHA citations, even under specific standards, there is the concept of actual or constructive knowledge. This is kind of the constructive knowledge aspect of the general duty clause. If it's so obvious that a reasonable person should have recognized the hazard was present, that's enough for OSHA to establish the second element. On the next slide, we talk about ways that OSHA goes about proving those different, those kind of three different ways that OSHA might prove hazard recognition. Looking again, industry consensus guidance, employers' own policies, employers' own injury and illness records. That's something, one of the reasons why OSHA always grabs your 300 logs and your 301 reports in the beginning of an inspection is they're looking to see, are there trends, are there patterns where there is a hazard that has cropped up in your workplace before, therefore you should have known about its presence. You should have known that it existed in your workplace. So even if there's not a specific standard, if you have past experience with employees experiencing heat illness, or past occurrences of workplace violence, or past occurrences of illness from exposure to a chemical for which there's no PEL, or for which you're achieving the PEL, but it's not necessarily a safe level, that's what OSHA is going to look to, those kinds of records, those kinds of documents, those kinds of statements to establish the hazard recognition. But the big one, the one that we see the most often, and this is one where I grow a little bit frustrated with OSHA about this, is it seems to me, in these major areas that I think Beeta is going to talk about some trends where we're seeing the most general duty clause citations, that OSHA is aware of the hazard. They believe it is an important issue, and so they are issuing their own guidance documents. And there's an example here on the screen of OSHA's guidance about preventing workplace violence in the healthcare setting. OSHA has issued this guidance, and they've updated it a couple times, and they put out press releases about it, and they speak about it, and they'll attach it to hazard alert letters, and they'll start, emphasis programs, and they'll attach it and link it in in those emphasis programs. And then when they do an inspection in a healthcare setting and they see examples of workplace violence, a patient on a doctor, or visitors or guests on doctors or nurses or whatever in the workplace, they'll issue that general duty clause violation, and they will point to in the citation itself as evidence of recognition of the hazard, evidence of feasible means of abatement, and evidence of employer recognition, the existence of their own guidance document. And, I get it. Compliance assistance is great. Education is great. And I think it's important for OSHA to issue these kinds of guidance documents. But when you see them sit out there for so long, just as a guidance document with no effort to promulgate a specific standard and citing over and over again their guidance document as though it is a standard, that's where we get frustrated, and we have those debates about, wait a second, is this a gap filler? Is this supposed to be a temporary placeholder? Because you're clearly aware at this point, OSHA, about this hazard of workplace violence in healthcare. Promulgate a rule, right? California has done it. You've been petitioned to do it, and you accepted a petition and have really advanced no further promulgating a rule. But that hasn't slowed you down from issuing these citations. And the reason is, I get it, producing a rule is hard, right? You've heard some of this data before, that sometimes it can take as much as a dozen years for OSHA to promulgate a standard, one that they're actually working hard on. So it's hard to produce rules. It's easy to produce guidance. So why bother with a rule if we can produce guidance and then just pretend like it is a standard? But that is the lay of the land right now. So you need to be aware of guidance that's out there, because OSHA is treating its own guidance as though it is the law, as though it is mandatory. And we're seeing that right now in the context of COVID-19. Amanda is going to talk about the guidance that OSHA has issued and how OSHA intends to use that to enforce, to basically treat it as mandatory regulatory requirements, even though there is no standard. So that's the main way that OSHA shows hazard recognition these days, tends to be its own guidance documents. And I think that's a shortcut. I don't want to say cheating, but it's I don't think it's the spirit of 5A1, but we see it incredibly often. The third element is serious. It's a serious hazard, that the hazard could result in death or serious harm. We view this as a very, very similar requirement to proving seriousness for serious violations, right? A serious violation of the lockout tagout standard is serious because the violation could have resulted in serious harm or death. So it's more or less the same kind of standard there. And an interesting aspect of that is, because this is an element of the general duty clause, you cannot have other than serious general duty clause violations. If the hazard that OSHA is trying to address through the general duty clause is not a serious hazard, it can't be cited. It is unlawful for OSHA to issue a 5A1 violation about a minor hazard. It is unlawful for OSHA to issue a 5A1 violation about paperwork violations where there is no hazard at all. And so it is important for OSHA to look for, and when you're evaluating the appropriateness of a citation you've received, is to look to, is it truly a serious hazard? Is it truly a hazard that could result in death or serious harm? And if not, that would become a defense to the violation. So here's guidance that OSHA has issued in its field operations manual, and then we've pulled from some important cases that have been issued in the past for what is serious physical harm. It is, injuries or illnesses that rise to a level of seriousness like amputations, concussions, crushing injuries, fractures, burns of various types, cuts, lacerations, and punctures, sprains and strains, and musculoskeletal disorders. That is not an exhaustive list, but it gives you a sense of the nature of the injury that warrants a general duty clause violation or a finding of potential for serious harm. And then illnesses of these type, respiratory illnesses, cancer, hearing impairment, central nervous system impairment, visual impairment, poisoning. Those are the types of illnesses that can give rise to a general duty clause violation. Those can be established by showing that an actual serious injury did occur, right? And that's where going back to that example of there doesn't have to be an injury, there doesn't have to be an accident, but if there is one, it's going to be easy for OSHA to show the existence of a hazard and to show the seriousness, the serious element that they have to prove if it resulted in a serious outcome. You can have accidents that have minor outcomes or non-accident situations where OSHA can still point to the circumstances and say it is likely that death or serious physical harm could occur even if it didn't in this instance. That's a harder showing for OSHA to make. But for certain types of issues, often for these illness cases, if they can show the exposure, even if at that moment in time no one has become sick yet, these silicosis, asbestosis cases, COVID-19 even, are situations where someone may not be sick yet, but if you're not taking measures to prevent those exposures, adequate measures to prevent those exposures, they could result in death or serious physical harm, even if that hasn't happened yet, even if no one has gotten sick at all. If they feel like you're not implementing appropriate measures, they could establish this third element of death or serious physical harm. The fourth element is, I would say, the other, co-equal to hazard recognition, where the rubber meets the road on proving general duty clause violations. And that is demonstrating that there is a feasible means of abatement that would materially or significantly reduce the hazard that is being cited in a significantly, a material way more so than methods that the employer is already implementing. So it's feasible, available, and likely to materially reduce the hazard. That's the standard that OSHA has to meet. It's not a violation merely because OSHA knows of some other thing the employer could have done. If that other thing, that other action, that other piece of equipment would not materially reduce the hazard more so than what the employer was already doing. It's not enough that there is something else the employer could have done. It has to be materially better. Examples of feasible means of abatement, ways that OSHA would show a feasible means of abatement exists would be looking at the employer's own hazard control methods that existed, that were in place, that were recognized and adopted by the employer, but were not implemented in a particular circumstances or basically weren't implemented at all. So if the employer, had, for example, a hard hat policy, but was not enforcing it, wasn't requiring it, wasn't providing them, that OSHA can point to that and say, well, the employer recognized the need for hard hats. It is feasible because they had some hard hats on the shelf. Some employees had them, others didn't. And it would have materially reduced the hazard. OSHA has to show that. But the fact that you weren't enforcing it, the employee in this instance wasn't wearing it, if it wasn't employee misconduct, that would be a way for OSHA to show a feasible means of abatement exists. Other ways to show it would be the measure the employer implements after the accident or the incident or the injury that is the subject of the enforcement. This is a frustrating one because this is like that, what's it called? Post-remedial measures are inadmissible in a civil wrongful death or personal injury case. In this context, OSHA can point to it and say, look, we know a feasible means of abatement exists because right after the employee got hurt, the employer went out and got this equipment or implemented this policy or started to enforce this policy. So we know that it was feasible and we know that it would be, impactful, and we know that it was recognized and available to the employee because they flipped a switch and did it as soon as somebody got hurt. And they can do that. You know, they can show that for establishing that a feasible means of abatement exists. More often, though, they will point to measures that other employers have implemented. They will point to measures that are recommended by original equipment manufacturer. You know, they'll very often see references in a general duty clause citation to statements or recommendations or requirements in the operating manual or the manufacturer's manual about equipment that was involved in the incident. And they will also look to trade journals, national consensus standards, trade association standards and best practices, things like that, to show that some feasible means of abatement existed, it was available, and it would have been effective. So that's generally the approach that OSHA takes in that regard. So let's go to the next slide, and we'll talk about an example of sort of all of the elements of the general duty clause a violation coming together. One thing we've seen quite often is OSHA looking to tools that are available under things like the HAZCOM standard. The preamble to the HAZCOM standard says that the purpose of the standard is to enable employers and employees to increase their recognition. Key word there, right? Hazard recognition is important under the general duty clause. The purpose of SDSs and labels and HAZCOM training is to increase recognition and knowledge of chemical hazards and to take measures to reduce chemical-related injuries and illnesses. So you could have violations of the HAZCOM standard, but if the HAZCOM standard doesn't quite fit, you know, you have the SDS, you've done the training, all your chemicals are labeled, but there's still unacceptable exposures to chemicals in the workplace. Well, OSHA can point to these various aspects of the HAZCOM standard to support a general duty clause violation. For example, the hazard exists in the workplace. We know this because we can look to the SDS or the label that tells us this chemical is hazardous. We see that it is here in a drum or a container and that employees are interacting with the chemical in the workplace. We know the hazard exists because your own SDS program, your own HAZCOM program tells you that that hazard exists in your workplace. We know that it is a recognized hazard because you have the SDS and you're required to consult them in implementing your HAZCOM program. They are labeled. The chemical product packaging is labeled, and it says right on there in pictograms and in words, this is a hazard. Therefore, you are expected to recognize that. That would be an easy way for OSHA to show recognition there. That this particular hazard is a serious one. That's not always going to be the case, but looking at your SDSs and labels, you will see, is this a chemical that can cause serious harm or death? It will usually say that in the SDS, what potential harm can come from exposure to the hazard or excessive exposure to the hazard. And those outcomes tend to include things that were in that bucket of serious injuries or illnesses that we talked about before: burns, cancer, other serious illness, respiratory illnesses, things like that. So with just looking at SDSs alone, OSHA can show that a hazard exists, that the hazard was recognized by the employer, that the hazard is likely to cause death or serious harm, and then feasible means of abatement. Once again, look at the SDS, look at the manufacturer's information about the chemical. Generally, it's going to tell you that is one of the major categories in the SDS is how do you address the hazards of this chemical through PPE, through engineering controls, through administrative controls. They're going to be listed in the SDS. So that's a way that OSHA can use things that are readily available in your workplace to knock off each of those four elements of the general duty clause. So the last thing I want to talk about here are limitations to sort of feeding into what might be defenses later that I think Beeta is going to talk about, but limitations to 5A1. 5A1 is not supposed to be used when there is a specific standard that applies to a hazard. We see OSHA creeping out of that limitation from time to time, especially in the context of citations for exposures to chemicals for which there is a PEL. But as a general rule, you are not supposed to be able to use 5A1 when there is a specific standard that applies to the hazard. 5A1 is generally not to be used to impose a stricter requirement than that imposed by an existing specific standard. Again, we're seeing some exceptions to that in recent years, but that is a general rule. A standard exists. If you comply with that standard, that should be tantamount to compliance with the law. End of story. The third limitation here, 5A1 shall normally not be used to require additional abatement methods not set forth in an existing standard. Again, if you're complying with an existing standard and taking the measures that are specifically called out and required by a specific standard, OSHA is not supposed to be able to come in and say, well, that's great that you used guardrails and that you had harnesses and lanyards, but we think there's something even better, so we're going to cite you under the general duty clause because we don't think that minimal compliance that you engaged in was enough. They're not supposed to be allowed to do that. And then a third really important limitation is that 5A1 is not supposed to be able to support criminal charges under the Occupational Safety and Health Act. There is a criminal charge available under the OSH Act for willful violations of a specific standard that caused the death of an employee. Because there is a requirement that it be a specific standard that's violated that causes the death, 5A1 violations are not supposed to be the underlying violation that supports a criminal charge under the OSH Act. So some important limitations there under the of how OSHA can use 5A1. And I think the last slide I'm talking about here is one that I've already sort of touched on throughout the program today, and that is this one area that we find frustrating a little bit because it defies and undermines what is generally understood limitations to 5A1, and that is OSHA's use of 5A1 in situations where there is an existing OSHA Pell, even if that Pell is recognized by evolving science to be set at the wrong level, to be not protective enough. But OSHA has had some success enforcing the general duty clause in those circumstances. We identify a couple cases here, interesting reads, if this is an area that you're particularly interested in, the Fiberdome case and the General Dynamics case were situations where OSHA was able to demonstrate that the hazard of exposure to a chemical, even at a level below an existing Pell, was well understood and well recognized by the employer, and therefore exposures at those levels, even though they were minimally compliant with OSHA's Pell, were still violations of the law. And in those cases, there were, I don't want to say extraneous circumstances, but there were extra evidence to show strong hazard recognition, right? An industry consensus standard that set its own new level because there was clear recognition that the level was not adequate. But there is existing right now, NIOSH RELs for almost every chemical that there is an OSHA Pell, and those do not align in many, many cases because NIOSH puts out those data points without rulemaking, right? They evolve more nimbly with science as science evolves. So, it will be interesting to see with a perhaps more aggressive OSHA administration whether we're going to see sort of rampant use of the general duty clause to enforce OSHA Pell or enforce exposures to chemicals even below existing Pells. And we have seen now a couple of different administrations, the Obama administration in particular, exhaust a lot of resources trying to figure out a way to update OSHA Pells in an efficient way. And there's just really not, they haven't found one. And I get it, right? Chemical specific rulemaking in particular is really hard. It takes a lot of time, and there's so many chemicals out there. It's hard to do it. And to update, these chemical specific standards or even Table Z would be a Herculean effort. And that's why we're seeing, them experiment a little bit more with the general duty clause in those situations. So look out for that. If that's an important issue in your workplace, we could talk offline about some key defenses to that or some important practices that you ought to consider in advance of any interactions with OSHA on that issue. Now I'm happy to turn it over to Beeta now to talk about some enforcement trends.
Great. Thanks so much, Eric. Okay, now that we've laid the groundwork for what a general duty clause citation looks like, I'm now going to go over what the enforcement trends are, what the data looks like. All right, so first let's look at the subject areas. And what you'll see here on this list are a bunch of topics where, as Eric mentioned, OSHA has tried to promulgate a rule, or at least has contemplated rulemaking, but to no avail. So for example, workplace violence. Eric mentioned this. As you know, there's no federal standard for workplace violence, but we certainly advise employers to include policies against workplace violence in their employee handbooks. And why is that? Because OSHA has and will enforce workplace violence hazards under its general duty clause. And not to give away too much, because we do have some case law on it in a couple of slides, but this can be particularly concerning, as Eric mentioned, in the healthcare industry, where it is a recognized hazard. Also, we have heat stress and heat illness, which is another topic that we have case law on, so I'm not going to give away too much. But one thing that is interesting about this, and actually about many of these topics, is that sometimes, as Eric mentioned, state plan states like California have specific standards on these topics, and that makes sense because state plan states are allowed to have requirements that are more stringent than federal OSHA standards. So for example, Cal OSHA has a specific standard on heat illness prevention, and it's specifically geared for outdoor places of employment. But in that case, if you are a covered employer in California, Cal OSHA would cite under that specific standard. And talking about Cal OSHA, another topic area that federal OSHA does not have a standard on, but that California does, is combustible dust. And this is a really fascinating one. You know, while I was at the CSC, we did a lot of work with combustible dust and looking at NFPA standards, NFPA 654, and the CSC actually, we did a combustible dust hazard investigation that was in 2006 and made a recommendation to OSHA to develop a combustible dust standard. That was the recommendation recommended that they base their standard on NFPA 654. But while OSHA, commenced rulemaking, I think in 2009, it obviously has not yet proposed a rule and doesn't look like it will in the near term. So for now, at least federal OSHA keeps enforcing under the general duty clause. But again, like I said, California does have a combustible dust standard. So if you're covered in California, then Cal OSHA will cite under their specific standard. Okay, and a few others include ergonomics, as Eric mentioned, respiratory hazards from air contaminants that are not covered by an OSHA PEL. And the last one that we have on this slide, and probably of most interest to everyone listening, is COVID-19, which Amanda will cover in depth in just a few more slides. But even before the pandemic, OSHA had been trying for years to establish an infectious diseases rule, but never did. So COVID-19 sort of falls under that broad umbrella category of infectious diseases, which is why we weren't surprised, at our firm at least, at the outset of the pandemic, that OSHA declared, it would be enforcing COVID-19 related injuries and illnesses under its general duty clause. Okay, now moving on to the numbers. So as you can see, we've color-coded these red and blue for a reason. You'll see that a number of the citations, the number of citations do go up and down sort of based on administration. So under Carter, you had a high of approximately, I think, 3,800 citations, general duty clause citations. And then the low with Reagan only a few years later at about, I think, around 500 citations. Then under President Obama, so moving forward in time quite a bit, we had around 1,600 general duty clause citations in 2010. But more recently now hovering around 900 citations in 2018 and about 700 so far this year. These are all for fiscal years. And one thing that we think will be interesting is to see how much the pandemic, COVID-19, sort of skews the numbers for 2020, if it does at all. Okay, now moving on to recent OSHA, or Occupational Safety and Health Review Commission, and court cases involving the General Duty Clause. So our first one, as promised, is Integra, and that's related to workplace violence. So what happened? Integra provided social workers who would go to clients' homes to identify their healthcare needs. Notably, the employer did not do background checks on their clients. So there was an employee, a social worker, who visited a client's home, I think during a visit in 2012, and that client had been violent in the past, and during this one home visit, the employee was fatally stabbed. And OSHA cited Integra under its general duty clause for workplace violence. So in this case, the commission affirmed the citations and deciding the case in March of last year. In finding that the hazard was recognized, like Eric mentioned earlier, the commission looked at work rules and training that addressed violence by Integra, policies that called for obtaining the client's history from family and from the community, and the employer's suggested use of the buddy system for any employee who felt uncomfortable going to a client's home. So that was how the commission came to decide that the hazard was recognized. And again, this was sort of a healthcare situation. So I think, as Eric mentioned, had this been, OSHA is not allowed to or shouldn't be citing under the general duty clause saying recognize hazard from, across industries. You can't really do that. Here, it was a little bit, I think, at least for the commission, a little easier to find because this was sort of healthcare related. And so the next part, as far as means of abatement, an expert testified and provided credible evidence that various abatement measures would have resulted, like Eric said, in that material reduction of the hazard. So here, the citation was affirmed. Okay, moving on to Sturgill, that's our heat illness case. There, a contractor on his first day on the job was replacing a flat roof on a hot or hot-ish day, and was told by his supervisor that there were breaks and to drink plenty of water. But 5 hours into his shift, the contractor collapsed due to heat stress and was fatally injured. Here, though, the commission actually reversed and decided to vacate the citation. The majority found that there was lack of fair notice because it was a difficult issue on how to define this term, excessive heat. Is that a specific temperature? Is it relative humidity? Do you use dry bulb temperature readings or wet bulb? And so on. So because there was no industry standard or a standard everyone knew about excessive heat, the commission decided to vacate the citation, and saying that the standard should be broadly applicable, not a unique employee injury situation.
In the context there, Beeta, just go back 1 second. It's an interesting one because the employee did actually die of heat illness, but there was, I think there was evidence in the case that the employee had some pre-existing health conditions that were very much exacerbated by this. And there was a line in that case from the review commission that said something about this is the general duty clause, not the specific duty clause. And the idea that someone's unique health condition might make something a much worse outcome does not mean it's a general duty on the employer to do certain things. Other issues in that case were that it was not a particularly hot day, and there was a big debate about whether it was hot enough that it was recognized to be a hazardous condition. And then there was also a big debate in that case about whether the employer had taken enough steps, because the employer did in fact have a heat illness program, and they did a little bit of acclimatization activity, and there was water available, and they had this employee doing the least laborious job at the work site. And so the idea, I share all that to say the idea that Sturgill was decided against OSHA does not mean that that OSHA cannot prevail on heat illness cases involving the general duty clause. I think a hotter day would have made a very big difference. An employer who did not have even those basic heat illness prevention protocols in place would have made a big difference in this case. So heat illness is very much a citable general duty hazard. It just, in those particular facts, it showed the difficulty, the high hurdles that OSHA has to clear. And then I would say the same thing is true of the Integra case. The fact that OSHA prevailed on that case does not mean that, every time that there is a violent incident in a healthcare context, that the employer is going to be found liable under the general duty clause. That employer was not taking some of the seemingly well-recognized measures that employers can take in terms of background checks, in terms of protections that can be provided. And it was a really, really sort of challenging work environment. These are home health visits as opposed to healthcare delivered in a brick and mortar setting where there are security guards, where there's engineering and administrative controls are a lot easier to implement. So we're seeing a mixed bag on those cases at hospitals. So the idea that, Integra and Sturgill are not to say that don't worry about heat illness or you've got no chance in a workplace violence case, but they are interesting cases to look at for sure.
Great, thanks, Eric. So just now moving on to general defenses to general duty clause citations. We've got a slide here that sort of gives a good overview of those. So the first set of defenses is really to attack OSHA's case. As Eric mentioned, OSHA has the burden of establishing those four elements of a general duty clause violation. So if you can disprove even one, they cannot win their case on the citation. So things like no hazard not recognized, no risk of serious physical harm, no feasible method to correct the hazard. And feasibility, we might want to add is, that goes to technical feasibility and economic feasibility. So you can attack it from either side. Also saying that, OSHA's proposed abatement would not materially reduce the hazard. Another defense that Eric mentioned is this, multi-employer worksite that, the employee was not our employee. So, the test that courts will usually go through to determine this is, looking at things like, the employer's nature and degree of control over the employee, the extent to which work performed is integral to the employer's business, whether the employment relationship is permanent, workers' investment in equipment and facilities, the worker's opportunity for profit or loss, and the level of specialized skill and independent judgment that the worker has. So if you can prove, looking at those factors that the employee in question is not your employee, that's you know, sort of an easier way out of the citation. Also, there is the unpreventable employee misconduct defense. That is essentially arguing that this was, you know, a one-off kind of occurrence, you know, that this employee, that it was specific to this employee, there was non-compliance, and that's what caused the injury or illness. And there you'll need to prove 4 elements for under the unpreventable employee misconduct defense, that, you know, 1, you had work rules adequate to prevent the violation. 2, that you effectively communicated those work rules to your employees through training, education, and the like. 3, that you had ways of discovering any deficiencies. So, you know, implementing audit programs, inspections, supervisory oversight, and 4, that you effectively enforce those work rules. So, you know, taking corrective action where needed when there are deficiencies. So that's also an affirmative defense that can relieve you of the citation. You can also argue greater hazard. That is essentially that, you know, complying with whatever OSHA cited you for would have resulted in a greater hazard than non-compliance. Or you can argue lack of particularity. Maybe it is that the citation is so vague, or, you know, the language they're using is so, you know, incomprehensible that you have no idea what OSHA is trying to allege. And then our last bullet is lack of knowledge. And just a point that this is different from hazard recognition in establishing a general duty clause citation. Lack of knowledge means that, as Eric mentioned, that you had no actual or constructive knowledge of any violation. So if the employee never, you know, reported the violative condition and you've never had any history of that violative condition, then you can argue lack of knowledge. So those are just some possible ways to beat a general duty clause by a citation. And now I'm going to turn it over to Amanda, who will speak more specifically about the general duty clause as it applies to COVID-19.
Great, thank you, Beeta. Hi, thank you for hanging out with us this afternoon and talking about the general duty clause. We thought a webinar on the general duty clause would be suitable. It would only be, or having a conversation with regards to COVID-19 in relation to it would be timely, given that's a subject we've all thought about a lot in recent months. OSHA does not have a standard that specifically addresses infectious disease, such as COVID-19, so it has to rely on standards that it has in place for different hazards associated with the virus, such as respiratory protection. And then they also use the general duty clause as kind of the filler for when there's not a specific standard that applies, like Eric discussed earlier in the presentation. OSHA lists the general duty clause as a relevant regulatory requirement in COVID-19 documents and guidance materials that they've put out on the subject. We can say that to this point, they have not issued any violations related to the general duty clause for COVID-related issues. However, this is a fairly new hazard coming from COVID-19. Really came on the scene in the beginning of March. So it's we're coming up about 6 months, which is the same time that OSHA has to conduct inspections and issue violations. We know they're certainly active with regards to inspections. So the next couple of months could possibly have that general duty clause violation for COVID-related activities or exposures. Eric and Beeta touched on the specific language of the general duty clause and the elements. And as we look at this page here, the 4 elements necessary to prove a violation. We talked about the hazard exists in the workplace, an employer or its industry recognizes the hazard, and the hazard is likely to cause death or serious injury. In this case, in evaluating general duty clauses through the scope of COVID-19, it's likely that OSHA would be able to establish these 3 elements. It's really the 4th element that kind of brings in a lot of flexibility and a lot of uncertainty with regards to feasible means do feasible means exist to abate the hazard? Going up to the next slide, there's a variety of guidance documents out there about things that the workplace can be done in the workplace and employers can do to address COVID-19. OSHA came out with guidance in early March for different types of employers, and they followed up with different section or industry guidance specific to different workplaces. A lot of the things that we're seeing in that guidance, and also through CDC guidance. CDC has been very involved in issuing guidance to workplaces with regards to COVID-19. And then we've also seen some guidance out of FDA for respiratory protection, and OSHA seems to be following that very closely. So those are some major sources of information, as well as industry associations. Coalitions are developing for retailers and other folks to put out best practices. And so all of those are kind of guidance documents that are out there. Things that we're seeing in a lot of these are implementing engineering and administrative controls, physical changes in policies to maximize social distancing, a shift towards remote work, signage communication for employees and guests regarding hygiene practices, how to identify sick employees, what are the symptoms for COVID-19, when should you stay home, providing a variety of information to employees so that they're knowledgeable about what steps they should take. Certainly supplying sanitizer and soap and cleaning supplies, making sure it's available. A lot of people have put in the additional sanitizing stations, the hand sanitizers, making it available at construction sites, some issues that have been going forward and seen in this context. Limit the workforce, seeing that in the manufacturing area, maybe separating folks so that there's more space between work areas, maybe slowing down the production line, certainly seeing it in meat processing facilities, staggering and rotating shifts. Instead of having everybody show up at the 8 o'clock hour, maybe doing it 8:39, just so you don't have a big influx of people all trying to get to the sign-in clock at the same time to minimize exposures. And also, if you're doing checks to monitor for temperature and health screening, don't want to pull long lines. So if we stagger them, they would be less people in line at one time. Enhance workplace housekeeping programs, especially important after there's been a COVID positive employee in the workplace, or any individual really, just not an employee. Discourage the sharing of phones, desks, office and tools. I think of a receptionist desk where somebody might fill in the lunch hour and not necessarily wipe down the phone and all the different equipment they might touch there and have somebody come in. So trying to minimize the sharing of office resources and tools. And then conducting a pandemic-specific PPE hazard assessment. A lot of seeing this in nursing homes, and a lot of folks just trying to keep up with the CDC guidance. So doing the exposure control plan and the response plan. Moving to the next slide. Talking a little bit more in detail about some of the different measures that we've seen employees implement and things that OSHA looks for and asks about when they conduct COVID-19 inspections. Asking about the ventilation systems, the increase, has there been an increase in ventilation rates? Have they brought in portable air sanitizers? In retail, have they put up sneeze guards or the plexiglass shields that we all see at the grocery store now that separate you and the cashier? Other things with regards to administrative controls, require sick workers to stay at home, virtual meetings, limiting the number of people that can be in a conference room at the same time, limiting and reconfiguring lunchrooms, and implementing telework where it's feasible. Job rotations and staggered shifts are also some other things that OSHA has recommended that employers consider as they work to minimize the hazards of COVID-19 in the workplace. Procedures to reduce duration, frequency, or intensity of exposures. wearing masks in the workplace when you're not able to have a 6-foot distance from all colleagues. There might be a certain thing where individuals got to be closer than 6 feet to lift a piece of equipment or for another reason, and having masks. Requiring regular hand washing with reminders, making sure there's plenty of soap. And then personal protective equipment. We'll talk a little bit more about face coverings in a moment, but also seeing shields, respiratory protection, especially important in the hospital setting, and gloves and gowns. So making sure that the employees have all of these things lined up and there's a plan, and communicating that to employees, I think, are all the things that OSHA is looking at with regards to COVID-19 at this point. Moving on to the next slide. Face coverings. Since this all started, we've all learned a lot about face coverings, respirators, and all the different categories, and also gotten a lot of questions about this. Just starting at the most basic level, and what is the CDC is recommending that everybody wear to minimize the exposures. And that is basically if you have an asymptomatic or a pre-symptomatic person, covering their mouth and nose so that they don't generate aerosols. And these face coverings are cloth masks, bandanas. We've probably all seen them. These are not considered PPE for OSHA purposes because they're not designed to, the primary reason, they're not designed to protect the individual. They don't have a tight seal around the face that would limit the potential for COVID-19 virus aerosols to come into the breathing space, but it's trying to limit the aerosols generated by those asymptomatic and pre-symptomatic individuals. So it is not considered PPE under 1910-132. The other type of masks that are out there are surgical and dental masks. These are usually a loose fitting. They do not have a tight seal around the outside of the respirator. They're oftentimes paper. And for PPE, and in the COVID context, these also are not considered PPE. They're still trying to minimize those transmissions from the asymptomatic or pre-symptomatic individuals. They can be PPE, especially in a healthcare setting or an operating room where they're protecting against splashes and sprays. They usually have some sort of plastic barrier that would prevent materials from being splashed in an individual's face. And if they are used in that context, they are considered PPE, and the employer is required to provide them and pay for them under 1910-132. However, in talking about face protection in the general workforce, OSHA has expressed, and through their guidance, that masks and mandating that employees wear masks where it's not possible to maintain a safe distance from other employees could be a means of feasible abatement in a control plan. We haven't seen this yet, but theoretically it's possible, and OSHA suggested that something that they're looking at in guidance is one of those means of feasible abatement to keep the rate of transmission low in the workplace is to mandate that all employees wear masks. So the bottom line is we're recommending employers who have a office setting or employees that are interacting within 6 feet of each other to provide masks and pay for masks, even though they would not technically be required under the PPE standard, which is the first place you look at or comes to mind with regards to face coverings. Going on to the next case, I talked a little bit about enforcement. We've not seen that OSHA citation under the general duty clause for a COVID-19 related issue, but we have seen 2 citations related to COVID-19. I believe both of them are in the nursing home context. One of them had to do with a reporting violation. It was either a hospitalization or an individual might have passed away due to COVID-19, and OSHA was alleging that they should have been notified of the employee death. So those are the 2 that we've seen so far. However, OSHA's been very active with regards to receiving complaints. At a certain point, they were keeping a Excel spreadsheet of all the complaints that they were getting related to COVID-19. And as part of the complaint process, they were receiving those complaints. Most times they would send out a request asking the employer to address the concerns and asking to see to address the concerns if any did exist and correct them. Have not seen a ton of follow-up from those responses that have been submitted, but OSHA's certainly been active with regards to that and the number of employee complaints that they've been addressing. They've also started to do some other interesting enforcement related to collecting information and sharing information from CDC and CMS and asking about reporting violations. So there's certainly some activity going on. Like I said before, they're still within their 6-month statute of limitations since this is a relatively new virus that's impacted the US and become a workplace hazard. So I think in the next couple of months, we'll have more of an idea of what their enforcement strategy is with regards to COVID-19. And I think that is the final slide, and we appreciate your time today. And if you have any more questions related to COVID-19 or General Duty Clause violations or what's required by the General Duty Clause standard, please feel free to reach out to us. Every month, there's usually one webinar. A lot of times there's more than one, especially in these times when new issues continue to develop. So here is a list, and we hope that you will join us in the future.
We have one we're about to announce very soon, I think is on August 3rd. We're going to do a program about the new Virginia emergency temporary standard on COVID-19 that was just adopted and will go into effect probably on August 1st, next week or the week after. So on August 3rd, we're going to do a program on that OSH COVID-19 standard as well, and look out for communications about others. I know we've sort of hit our about the hour and 15, which is our typical our target run time for these programs. So if you folks have to drop off, that's fine. We do have a handful of questions. Maybe we'll address a few of these, and if folks want to stick around for questions, keep typing them in as well, and we'll go through some that I've seen come in throughout the program. There was a question from the earlier discussion about the multi-employer context, the idea that 5A1 violations generally should only be permitted in circumstances where your own employees are exposed. Well, what does that mean, exposed? Is that your employee is present at the workplace or something more than that? And this is essentially the exposure analysis under the General Duty Clause is the same as the exposure analysis under that is a fundamental element of every OSHA violation under any standard, however it's characterized, is employee exposure. And that means reasonably foreseeable exposure. So it should not be enough that the employee is merely present in the workplace. It requires a foreseeable exposure to the actual hazard. So if it is, combustible dust is the hazard that's at issue, is the employee in a location where they could be impacted by a combustible dust event. If it's heat illness, is the employee working, outdoors for an extended period of time in high heat conditions, or is the employee present but only working indoors in climate controlled areas? It has to be actual exposure to the hazard, foreseeable exposure to the hazard, for that to apply to a multi-employer situation. There is a question about feasible abatement. Regarding feasible abatement, can abatement measures be put in place? Can abatement measures that have been put in place at sister facilities of the same company be used as justification of enforcement and citation under the General Duty Clause? And I would say 100% yes. And that is, one of those reasons why we talk to employers about consistency and good communication across sister facilities. Because they're going to, be able to demonstrate that, there's awareness and availability of that abatement to the employer if they are implementing some practice at a sister facility. I think if OSHA becomes aware of that and has access to that during an inspection, you can count on them using that and pointing to that, not only for, hazard recognition and feasible means of abatement, but perhaps even the characterization, right? I talked earlier about how General Duty Clause citations can't be characterized as other than serious. Well, they can be characterized as willful and repeat. And so if you've got, good evidence out there that you're aware of the hazard, you're addressing it all over your enterprise and sort of willfully not addressing it at one particular location, that could be used not only to prove those elements, but also to prove an intentional or reckless disregard to help establish willfulness. Some other questions I've seen. Somebody asked about if the general duty clause can be used to cite combustible dust hazards, and we have seen quite a few of those. Combustible dust hazards can be cited under a variety of specific existing standards. There are standards out there, under fire prevention, fire protection, and things like that. Standards about bag houses that exist. How they should be designed. I'm talking about specific OSHA standards, as well as sort of OSHA's grain industry standards. So combustible dust in the grain industry generally has to be cited under 272 and therefore can't be cited, we think, under the general duty clause. But outside of a context where there's a specific standard, absolutely, they can and they do cite the general duty clause often in the context of combustible dust. They have, and I think they still do have actively running a national emphasis program on combustible dust. And we looked at some data from that program a few years back, and it was, it was not leaning as heavily towards general duty clause violations as I expected, but I think it was something like 30%, 20 to 30% of citations issued under that program were being issued under the general duty clause, most often with reference to things like NFPA standards applicable to certain industries. So that's a good example of OSHA looking at industry consensus standards generally applicable to a specific industry for a hazard that they're actively enforcing and using the general duty clause for it. It's an interesting question here about use of the general duty clause under PSM. And this is one of those examples where, generally we would say OSHA should not be dabbling with the general duty clause in a PSM covered process for issues that are covered by the elements of the PSM standard, because there's an existing standard and that's all that OSHA should be using. But we have seen, and I could surely see OSHA doing this often, using the general duty clause citation to cite things that are not part of a covered process and trying to overlay PSM principles to non-covered equipment. And one example of that, and I'm steeped in this. Unfortunately, we've been involved in the long-running case, the Wynnewood case, that's now before the 10th Circuit, waiting for a decision. That involved a utility steam boiler explosion, and in that case, at that refinery, when it was owned by a previous owner of the refinery, had a similar boiler incident years earlier, and OSHA cited that under the general duty clause and cited the company for not implementing good work practices to prevent explosions involving utility steam boilers. Because at the time, OSHA acknowledged what I think is abundantly clear even today, is that utility steam boilers are not covered by the PSM standard. But OSHA said it's equipment at a refinery where there is potential for catastrophic consequences, and there's recognized practices for maintaining and operating boilers. So here's a general duty clause violation for not implementing some basic process safety principles for your operation of boilers. OSHA did not prevail on that for different reasons. And then ultimately in this case that's on appeal before the 10th Circuit now, they just said, what the heck, let's just go ahead and say it's covered by the PSM standard and not have to rely on the general duty clause. I think that's an unlawful application of the PSM standard, and we're fighting that, and fingers crossed will prevail before the 10th Circuit. But you can see, and I could foresee circumstances like that, where you've got something at a specialty chemical manufacturing facility that's below threshold quantities, but the employer not taking recognized feasible means of abatement to address explosion hazards, even if it's not covered by the PSM standard, not implementing a mechanical integrity program, not implementing good operating procedures for that equipment. Yeah, we've seen that before, and I could see that absolutely applying. You're aware of a hazard, you're aware of measures to prevent that hazard from occurring, an explosion or release of highly hazardous chemical, even if there's less than the threshold quantity of chemicals. So an interesting issue there. See, a question about the percentage of contested citation. What percentage of contested citations does OSHA win, and at which level of contest? And it's an interesting question. I think there is something like, and Amanda or Beeta, if you know the number or if it's fresher in your mind, I feel like it's something like, fewer than 20% of citations, or maybe it's around 25% of citations are contested, but that doesn't mean those cases go to a hearing. In fact, very few end up going to a hearing. And the idea of how often OSHA wins, cases that are contested but ultimately still resolved by settlement, it's hard to define who wins, right? There should be some give and take and a compromise situation, so everybody or nobody wins in that context. But cases that are tried and decided in favor of employer versus OSHA, I'm sure that data point exists somewhere, but I haven't seen it. I don't know that specifically. A summary of the basis of general duty clause citations, meaning what issues are covered. That data has been tracked by OSHA, and that's largely where our slide came from. Is there's a data point that OSHA tracks what they call novel cases, or I think it's novel cases is what they call it. And that tends to be almost entirely general duty clause citations around certain issues, and they identify what those issues are in percentages. And over the last, I'd say 6-7 years, it's been a pretty heavy dose of workplace violence, heat illness, and the other issues that were on the slide that Beeta talked about. Feasibility, is there a general sort of dollar amount viewed as economic infeasibility? And what considerations does OSHA bring to an analysis there? There's not a specific dollar amount, but there is a concept, a standard essentially for what is economic feasibility. And it's extraordinary, and I think the wrong standard, but the standard that is largely adopted by the Review Commission and the Federal Circuit Courts is, can the employer implement this measure without going out of business? And that is a pretty extreme standard, and I think through negotiation and through discussions with OSHA, you can tend to find a little bit more reasonable ground. But that is essentially the legal standard for feasibility in the OSHA context. Can it be done without going out of business? So that's a tough one to clear. Let's see. Anything else? I don't know, Amanda or Beeta, if you've seen any other questions that you wanted to try to address here.
I saw one question. I mentioned that there's a spreadsheet that OSHA has with regards to COVID-19 complaints. It is not in their OIS system or their online database. I recall looking at it. It might be under the Freedom of Information page, FOIA page, where they post some of the things that people are asking for. It does not identify employers specifically, but gives a number. So
Yeah,
if you have the number.
Actually, right now, I mean, and this may change over time, but right now that is right on OSHA's homepage, I believe.
Okay.
You go to OSHA.gov, at least the version that I'm looking at, I assume everybody sees the same thing. Down on sort of on the right column of the page, there is a picture of the coronavirus, of the virus itself, the molecule, and it says COVID-19 response summary. And there is daily enforcement data and daily whistleblower data, and that shows that numbers of employee complaints, numbers of inspections that have been opened. That's probably going to roll up eventually to where Amanda just laid it out, but right now it's on the homepage, and that's where you can find that.
Excellent. The next question is one that we get frequently and we deal with frequently. It has to do with when to report a hospitalization or a death related to COVID-19, an employee hospitalization or death. And as the individual who's asking this question mentions, it's a challenge to determine the source of transmission, especially in areas where you have a high community rate of the virus. It's really hard to tell. I don't know if you want to give your perspective on that, Eric. I know he has
Sure.
very strong perspective on reporting those.
Yeah, so first of all, I'll just add one caveat before I start talking. OSHA has its own unique reporting requirements, and California has certainly a bias towards reporting, a presumption of work relatedness, and if it's a close call, report, and it can be reportable even if it's known to not be contracted at work if there are symptoms being experienced or onset at the workplace. So California does things differently the way California is wont to do, but everywhere else in the country, essentially, I think it is, first of all, virtually impossible to have a reportable hospitalization and very difficult to find a reportable fatality. The reason is to be reportable at all, it has to be a confirmed case, meaning there's a positive test of a respiratory specimen. Can't just be self-diagnosis or even a subjective diagnosis by a medical professional. It has to be a confirmed case, and it has to be work-related. And work-related, as defined by federal OSHA in guidance for COVID-19 cases, says that it is more likely than not that it was the exposure that caused the illness was an exposure in the workplace, and to determine whether it's more likely than not whether that exposure, that a workplace exposure was the cause, you look to reasonably available evidence and in the absence of alternative, equally likely non-work explanations for the illness. So if there is an identifiable non-work exposure, the employee lives with someone who's sick, the employee rides public transportation to work, the employee went to a 4th of July celebration, or went to a restaurant, bar, grocery shopping without a mask, anything like that, you could point to as a non-work explanation that is equally as likely because it's invisible and exposures are essentially ubiquitous, then it is not going to be work-related based on FedOSHA's guidance. So really hard to get to confirmed case and work-related. And then for hospitalizations, here's my take on this is that the law says a hospitalization is reportable for illnesses if the employee is admitted to the inpatient service of the hospital within 24 hours of the exposure that caused the illness. And so that just doesn't exist. That just doesn't happen with this virus. It tends to take at least 2 days and often more to experience any symptoms at all, let alone symptoms so severe that you're going to be admitted to the inpatient service of a hospital. So from an epidemiology standpoint, I think it is almost impossible to have a reportable hospitalization. Because it's got to be a confirmed case, has to be work-related, steep uphill climb, and have to be admitted within 24 hours of the exposure that causes the illness. For death cases, it's more likely the employee has to succumb to the illness within 30 days of the exposure that caused the illness, and there are plenty that are happening more than 30 days, but certainly many that do occur within 30 days. You still have confirmed case, much more likely in a death case. Work-relatedness, though, very difficult to show regardless. So I think it's going to be very difficult to run into those circumstances. There's a question in here that asks, should you err on the side of reporting? That's a personal preference and a professional or a business decision. My view tends to be, I don't make courtesy reports about anything because I seldom see OSHA showing courtesy back to the employer when we take, say, we don't think this is work related, but as a courtesy, we're making this call. Well, you're opening yourself up to an inspection and an enforcement action. If you have a very defensible position that it's not recordable or reportable, I don't record or I don't report if I don't believe it meets the criteria for recording and reporting, especially when OSHA is now out there conducting, over almost 1,000 inspections have been open, and we're not even 6 months into the pandemic yet. So that's my view of reporting. Happy to talk about this offline. And also, just anybody who's got similar questions, I know this is a frequently asked question and something you're grappling with. We've got some really tremendous resources on our website about this. On our COVID-19 task force page, we have it's right down. You can see that pretty kind of looking flow chart. Our record keeping and reporting resource guide. It's got a recording, a COVID-19 recording flow chart, a COVID-19 reporting flow chart, a how-to one-pager on how to record if you determine it's recordable, and then a really good, 30 question deep questionnaire that can be used to assess whether a case is work-related whether a COVID-19 case is work-related. So check those out. If you're having trouble finding them, just shoot any of us an email. And of course, if you have questions about a particular case, don't hesitate to reach out. We love talking about this stuff. We love to be a resource to you. I think that is all we have time for. I do see there are a few more questions. We'll try to tackle some of these by email after the fact, but I really appreciate everybody's interesting questions and everybody sticking with us and joining us for another program. And I hope to see many of you on August 3rd when we talk about the new VOSH COVID-19 standard and then the rest of the programs that we put on throughout the year as well. So thanks everybody and stay safe and stay well.